Double taxation and permanent establishment in cross-border activities, interaction with double taxation agreements and corporate tax law. Double taxation is a complex issue that arises in the context of international business and cross-border activities. It occurs when two or more jurisdictions claim the right to tax the same income or business activity, potentially leading to the same income being taxed more than once. This situation is commonly referred to as double taxation, and it presents significant challenges for businesses and individuals engaged in international trade or operations. However, the issue of double taxation can often be mitigated or avoided through double taxation agreements, DTAs, which are treaties between countries designed to clarify the taxing rights of each jurisdiction and prevent the same income from being taxed twice. 1. Permanent establishment and its role in double taxation. In the realm of corporate tax law, the concept of permanent establishment, PE, plays a central role in determining a jurisdiction's right to tax foreign entities on the income derived from their activities. A permanent establishment is generally understood to be a fixed place of business through which a foreign entity conducts its business operations. This can include an office, a factory, a building site, or even a branch of a company in another country. When a foreign business has a PE in a jurisdiction, that jurisdiction may claim the right to tax the profits derived from the activities carried out through that PE. The UAE follows the principles outlined in Article 5 of the OECD Model Tax Convention on Income and Capital when defining a permanent establishment for the purposes of its corporate tax law. This definition is widely accepted and utilized by many countries, making it an internationally recognized framework for determining when a foreign business has a taxable presence in a country. 2. The role of double taxation agreements in determining permanent establishment. When a foreign business is engaged in cross-border activities, it is essential for the business to assess whether it has a permanent establishment in the UAE, as this could trigger tax obligations under UAE corporate tax law. However, businesses must also consider the relevant double taxation agreement, DTA, between the country of residence of the foreign entity and the UAE. Double taxation agreements are designed to allocate taxing rights between jurisdictions and provide mechanisms to avoid or reduce the incidence of double taxation. DTAs typically contain provisions that address how and when a permanent establishment in one country will be taxed. Under these agreements, the country where the permanent establishment is located, the source state, in this case, the UAE, generally has the primary right to tax the profits generated by that permanent establishment. However, the exact terms of each DTA may vary, and it is important to consult the specific DTA to understand the taxation rights and obligations that apply. 3. Assessing permanent establishment based on the nature of the business. In assessing whether a non-resident person, a foreign entity or individual, has a permanent establishment in the UAE, several factors need to be taken into account. First, the nature of the business being conducted is crucial in determining whether it constitutes a permanent establishment. For instance, a foreign business that sets up a branch office or operates through a fixed place of business in the UAE could be deemed to have a permanent establishment under the terms of the OECD Model Tax Convention and the UAE's corporate tax law. Furthermore, the specific facts and circumstances surrounding the foreign entity's operations in the UAE will be examined. This includes where the business activity is carried out, whether the business has a fixed place of business or personnel acting on its behalf, and whether the business activities involve any significant economic presence in the UAE. 4. Resolution of conflicts between corporate tax law and double taxation agreements. In situations where the provisions of a double taxation agreement conflict with the corporate tax law of the UAE, the terms of the DTA will take precedence. DTAs are international treaties that supersede national tax laws, and their provisions are binding on the signatory countries. Therefore, If a DTA includes specific rules about the taxation of income derived from a permanent establishment, those rules will override the provisions of the UAE's corporate tax law. For example, if a non-resident person has a permanent establishment in the UAE but the terms of a double taxation agreement between the UAE and the foreign entity's country of residence dictate a different treatment or tax rate, the DTA provisions would apply instead of the general provisions of the UAE corporate tax law. This ensures that the foreign entity is not subject to double taxation or taxed in a manner inconsistent with the provisions of the agreement.